ADR stands for Alternative Dispute Resolution. It includes any method of resolving a dispute without using the courts. There are different methods of ADR. The first method of ADR is negotiation. Anyone who has a dispute with another party can always try to resolve it by negotiating directly with them. So, in this method, it is kind of direct negotiations between the parties. The second method is conciliation. In this method, there is a neutral trained person, the conciliator, who helps the parties reach a compromise solution. In this method, the conciliator plays an active role in the process and is expected to suggest grounds for compromise and possible basis for a settlement between the parties. The third method is mediation. In this method, a neutral trained mediator helps the parties to reach a compromise solution. The role of a mediator is to consult each party and see how much common ground is there between them. The mediator will not play an active role in the process, will not share their own views, will just act as a facilitator. As there are four methods of ADR, the last one is arbitration. It is governed by the Arbitration Act 1996. In this, there is the voluntary submission by the parties of their dispute to the judgment of some person other than a judge. The Arbitration Act 1996 only applies to written agreements, written arbitration agreements. Under Section 15 of the Arbitration Act 1996, parties are free to agree on the number of arbitrators, so there can be a panel of 2 or 3, or it can also be a sole arbitrator. And if the parties cannot agree on the number of arbitrators, then the Act provides that only one arbitrator should be appointed. There are different forms of hearings in this method. The parties can opt for a paper arbitration where the two sides put out all the points they wish to raise into writing and submit this together with any relevant documents to the arbitrator. A decision will be based solely on the documents. And when necessary, witnesses can also be called to give evidence. Time, date, and place of arbitration hearing are all matters for the parties to decide in consultation with the arbitrator. And the decision made by the arbitrator is called an award and is binding on the parties. It can even be enforced through the courts if necessary. The award is final, though it can be challenged in the courts on the grounds of serious irregularity in the proceedings or on the point of law. Thank you. Do subscribe my channel.